Okay, welcome everyone. We are going to get started and begin with an introduction from our faculty director, Jessica Silby.
Hi everyone, I'm Jessica Silby, and for those who weren't at the previous panel, this will not be a repeat. This is the third annual CLIC conference, and CLIC, the Center for Law Innovation and Creativity, is directed by Tony Morgan, who you just heard from, and I'm the faculty director. We're so sorry not to be doing this in person, but quite excited to take advantage of this digital platform and the ability to talk to people from all over the world, frankly, with no well, I guess I won't say no carbon emissions, with fewer for travel. And of course, the first thing I want to say is that we're on the eve of probably the most important federal election of our lives. And that's what we're here to talk about in part. But I just want to say, I hope everyone's voting. I hope you have a plan to vote. Maybe you've already voted already. Or maybe you're going to be bringing people to the vote or helping people vote. Either way, that's what I want to emphasize first. And then the second thing I'll just say by way of introduction is, the digital technologies that we're going to be talking about, that we talked about in the last panel with regard to health, and we'll be talking about in this panel and going forward, of course, doesn't promise the democratic outcomes that we hope for. And so one of the things we'll be talking about is how one way to preserve the best parts of humanity is through these kind of human connections, which they make available, but don't necessarily regulate always to the good. And so after this panel, we'll have a keynote by the amazing Ann Nelson. Right after the keynote, where she'll be talking about truth and misinformation in journalism, we have a film screening of In the Event of Moon Landing by two artists, Fran Panetta and Halsey Bergen, and that video screening is at 12:45 in Zoom Room B. Some people call it a deep fake, other people will call it art. And part of the conversation in the last panel today will be about the role of art in democracy and sustaining some of the fundamental values that we want to see going forward. I hope you will stick around for all of that. Say hello to some of our colleagues, Woody Hartzog at Northeastern and Ari Waldman. Brooke Baker is here. Cara Swanson and Pat Williams will be coming too. Claudia Haupt. All of our faculty and many of our students will be joining us for some part of the day. And after each panel, there is a 10-minute break in the room to continue chatting if you'd like, before we move on to the next Zoom room, the alternate Zoom room for the next panel. So thank you very much for being here. Welcome, and we look forward to the many conversations we're going to be having. Woody?
Excellent. Thank you, Jessica. I want to give a quick thanks also to Tony and everyone working with CLIC to pull this event together. It's a pleasure to see you all virtually. So our panel today is on privacy and democracy. And I just wanted to tee up why we wanted to pull this panel together and what it's about. So privacy and democracy have always been, at least in my opinion, tightly wound together. So fundamentally, the US commitments to free expression and freedom of assembly can't be realized without creating the room that privacy supplies for things like experimentation, safety, play, failure, and speech without fear of scrutiny from those in power. I think this is particularly true for marginalized voices that bear the brunt of surveillance and other privacy invasive activities first and most intensely, particularly people of color and people in the LGBT community. Privacy is also a key concern with respect to the vital government transparency frameworks that ensure that people have the information they need to hold government accountable and meaningfully engage in self-governance. But even beyond these fundamental dynamics, I think privacy has recently become acutely intertwined with our democracy as platforms like Facebook, Twitter, TikTok, and other social media companies, along with the deeply entrenched ad networks that are powered by surveillance and personal data, engage in micro-targeting and algorithmically driven content moderation based on our personal data. Tools of surveillance are shaping what we see, what we can click on, and that shapes our discourse and has a profound impact on our democracy. Additionally, powerful new surveillance tools like facial recognition are being deployed by law enforcement authorities as well as companies and private people to shame and discourage those who would choose to assemble and speak out against injustice, as we saw this summer with protests against racial injustice. I think we are at a key inflection point in our democracy, and privacy is a very significant part of this story. I'm so excited to have the three guests that we have with us today, and to have this space to explore what's going on and what we might do about it. I briefly would like to introduce our panelists and then turn it over to a few minutes of presentations. Each panelist will present some initial comments. I'll then maybe ask a question or two to the panelists, and then we'll get to what I consider to be the best parts of any panel, which is the Q&A section, where we can have some discussions about the issues that were raised. So first we have Rebecca Green, who is a professor of the practice of law at William & Mary Law School and co-director of the election law program. Professor Green's research is squarely in the topic of our panel today, focusing at the intersection of privacy law and elections, most recently on the topic of election transparency. Her research lives at the heart of what we're talking about, and I'm excited to read everything that Rebecca writes, because I always come away feeling enriched by a deep and careful study on a topic that in our privacy law community, I have to say, is often glossed over in a lot of obsessions over things like data protection minutia or other things. All right. Next, we have Salome Vijoen, a joint postdoctoral fellow at the NYU School of Law, Information Law Institute, and Cornell Tech Digital Life Initiative. She is also a former fellow and current affiliate at the Berkman Klein Center for Internet and Society at Harvard University. Salome studies how information laws structure inequality in the information economy and how alternative legal regimes may address that inequality. Relevant to our discussion today, Salome is working on the political economy of data and how laws that govern the data economy shape initiatives for downstream uses of that data, which, as I imagine she'll discuss, can lead to social oppression, worsen economic inequality, and inequality in our relationships, which all have an impact on our democracy. And I'm so excited to have Salome here with us, but to also generally have her as part of our technology policy community. And last but not least, we have Professor Ari Waldman, who has joined Northeastern's faculty in 2020 as a professor of law and computer science, just like me, with a joint appointment at the School of Law and the Corey College of Computer Sciences. Professor Waldman studies asymmetrical power relations created and entrenched by law and technology, with a particular focus on privacy, online harassment, free speech, and the LGBTQ community. Professor Waldman is widely published with two incredible books, one that you are able to get right now, Privacy as Trust, Information Privacy for an Information Age, and one that is on its way, Inside the Information Industry, which you have not read, but I have read drafts of, and I can tell you is going to be absolutely phenomenal. Professor Waldman regularly publishes in the popular press, was named one of 2020's top 50 thinkers by Prospect Magazine, and is also the founder of Legally Queer, a social media project that educates the public about the history, present, and future of LGBTQ freedom. And also is the proud new owner of Peabody the dog, who may make an appearance if we're lucky. So thank you all for your presence, and thank you all to our panelists for being here. Rebecca, why don't you get us started?
Great. Well, thank you so much, Woody. I'm so glad to be here. I'm sad we're not in person because I was really looking forward to this event last May. But I just am so excited because, as you mentioned, this is sort of right in my space. So I'm really happy to be invited. Thank you so much to Tony for all of her help with the logistics of both last May and today. And I'm just very pleased to be part of this great event. So I'm just going to launch right in. So the mantra among privacy scholars has long been that the protection of American privacy rights is central to maintaining a democracy. An early theorist to explore this connection was Alan Weston, who wrote in the 1960s and carefully chronicled privacy as a democratic value. He was writing at the height of the Cold War and painstakingly documented the many ways in which a lack of privacy was the mark of a totalitarian state. The expansion of privacy, he argued, enabled democratic citizens to form thoughts and engage in democratic betterment. And for Weston, privacy was a good that every American citizen ought to seek and enjoy. Modern scholars have continued to make this connection between privacy and democracy. One good example is Neil Richards, who in his 2015 book called Intellectual Privacy argued that the modern surveillance society has led to dramatic incursions in Americans' ability to think, communicate, and form thoughts. He argued that privacy is deeply intertwined with democratic citizenship and that surveillance, both commercial and governmental, threatens that value. The common theme among privacy scholars has been a consistent drumbeat that privacy is necessary for democracy to thrive. Back in 2018, Michelle Gilman and I published an article called The Surveillance Gap. We offered a counter narrative to the idea that over-surveillance is the only privacy harm to worry about. We wondered, does too much privacy at the other end of the spectrum also cause harm? We've seen incredible work documenting how underprivileged people often lacked privacy. Examples include people in jail or welfare recipients. The narrative among privacy theorists has been clear. Those who have wealth and sophistication are able to effectively protect their privacy, and those who lack wealth and sophistication cannot enjoy it. Our surveillance gap piece took this up, identifying two distinct phenomena that this narrative leaves out. First is the existence of the surveillance gap itself. As examples, we pointed out that undocumented immigrants and low-wage workers are very hard to find, let alone surveil and keep track of. Second, we argued that these groups experience harms as a result of too much privacy. They're exploited and they have lack of access to basic services. It's very difficult to find them to help them. Michelle noticed this in her work running a legal aid clinic in Baltimore. I noticed this in a project I co-founded at William & Mary Law School called Revive My Vote, where we help Virginians with felony convictions regain the right to vote. When we started RMV in 2013, Virginians with felony conviction histories had a tough time getting their right to vote back. We used to use supervising attorneys to help applicants navigate the then complicated law of rights restoration in Virginia. In 2014, Terry McAuliffe became governor and decided to make the process radically easier. But his office encountered a striking problem. It was really hard to find people eligible for rights restoration, especially those people with older convictions who had fallen off the map. People who have been released from the criminal justice system tend to move frequently and take steps to avoid the government gaze. And as a consequence, they're really hard to find. Remarkably, administrative typos, maiden name changes, and other kind of minutiae contribute to this problem. As a privacy law professor, someone who spreads the gospel of the harms of surveillance as a profession, I was shocked that the Virginia state government apparatus lacked the resources and ability to find people to give them the right to vote back. Shouldn't that be easy? In a surveillance of society, how could it be possible that the government couldn't find people? This realization leads to important conclusions, especially in the context of democratic citizenship. Too much privacy undermines important democratic values. It takes away the democratic voice of huge swaths of American society. We're seeing this unfold in even greater relief today, and I'm just going to mention quickly two examples. First, in the voting rights realm, and second, with respect to the US Census. So I'm going to start with Florida, felon voting in Florida. On October 7th of this year, ProPublica published an article that began this way. Nearly 2 years after Florida voters approved a landmark constitutional amendment allowing felons to vote, state officials don't know how many have registered. They also don't know how many felons on the voter rolls owe court fees, fines, or restitution that would disqualify them from voting under a subsequent state law that limited the amendment's scope. Let's back up for just a quick second. In 2018, over 60% of Floridians voted to restore the voting rights of people with felony conviction histories. The Republican legislature subsequently passed a law, which the 11th Circuit upheld last month, confining rights restoration to only those who have paid their fines and fees. Michael Bloomberg and many others have raised millions of dollars to pay the fines and fees of people who would otherwise be barred from voting, which you would think would solve the problem, or at least solve a lot of the problem, but not so fast. The problem is that it has been virtually impossible to figure out how much people owe. Why is that? It's because Florida doesn't have a centralized database that lists courts' fines and fees. You have to go to individual counties, and even within individual counties, especially old records, are really hard to produce. That means not only is it next to impossible to pay fees for them, but it also means that the state has no idea of those who registered since voters passed the constitutional amendment in 2018, whether those individuals are now ineligible to vote and or may face prosecution if they attempt to do so. It's hard to believe that this is all happening in what we think of as a surveillance society. What is a travesty and directly affects, while this is a travesty and directly affects not only Floridians caught in this data desert, but also if the vote comes down to Florida, as I very much hope it doesn't, it could affect American democracy writ large. A second example, which I won't go into in as much depth, is the US Census. So the census has long been plagued by an undercount, which is a literal manifestation of the surveillance gap. The census not only determines representation in federal and state governments, but it's also tied to billions in state and federal funds that communities receive. This year, we are witnessing a deliberate thwarting of democratic citizenship through the purposeful and knowing expansion of the surveillance gap, not only through cutting counting short during an already pandemic thwarted count, but the push to remove undocumented individuals from the tally altogether. As in the felon voting example, the impact on democracy is direct. The story of the surveillance gap is one of haves and have-nots. Some residents of the surveillance gap lack political voice by the nature of democratic structures. We already don't allow, for example, non-citizens to vote. But the features of American democracy that are meant to give voice to residents of the surveillance gap, both directly and indirectly, are being actively undermined. Don't even get me started on the connection between the surveillance gap and public health during a pandemic. I could go on for quite some time, but for now, I think I'll just stop there.
Excellent. Thank you very much, Rebecca. I'm clapping. The thing that I really miss about good Zoom conferences is that it's hard to get a good clap up and working simultaneously. Okay, so next we will hear from Salome.
Great, thank you. So I think following off of Rebecca, I'm going to kind of reverse the premise of the panel a little bit to say, instead of what privacy can do for democracy, I'm going to be exploring a little bit what democracy and forms of democratic institutional governance can do for a number of privacy problems. So what I'm kind of going to be arguing is that these forms of social relationship that we find ourselves in are really central to how the digital economy works, how it produces both the economic value that drives a lot of the data collection that happens, as well as how a lot of forms of social risk get introduced in the digital economy. But this kind of centrality to these social relationships that information production puts us into are largely absent in our data governance law, our privacy laws. And kind of ignoring this sort of important social component to how information production happens can kind of prevent effective data governance, but more importantly, can also allow certain forms of injustice, particularly relational and distributive injustices, sort of prevents them from being represented, let alone addressed in our data governance. So to illustrate the point, you can consider this scenario. So we have a data subject called Adam, and he's a tattoo enthusiast and a reformed gang member. And so Adam uploads photos of his tattoo images to this social media site called Tattoo View. Now, Tattoo View, their social media site, and they aggregate and synthesize all of the data to sell insights about tattoo enthusiasts to advertisers that want to advertise to these people. But we can very plausibly imagine that they've also recently partnered with local law enforcement who can access this tattoo database and use this sort of advertisement predictive program to identify and predict which tattoos are signs of likely gang membership. And this predictive system helps them to identify that the tattoo image that Adam uploaded is likely a sign of gang membership. So they then use this information to detain another person, Ben, and question him for suspected gang membership on the basis of this tattoo that he shares with Adam. So this scenario, which I would argue is very common throughout the digital economy, kind of raises a few problems for the traditional way that we think about privacy and the sorts of privacy problems that privacy law worries about. So normally we would be asking questions like, was this information collected with Adam's consent? Was he manipulated into giving these images? How does maybe this sort of form of collection erode or put into potential danger Adam as an autonomous subject? But none of that really gets at the impact that this data flow has on Ben. So the basis of these sort of shared relational features, the fact that the tattoo image about Adam is really also sharing really important information about Ben, in one way kind of presents a classic externality problem. It's a relevant feature that isn't being represented, but it also kind of has this flavor of injustice. So we could imagine that above and beyond the classic externality problem that this might be presenting, let's say that Ben is Black. Now we have a problem that kind of has a different normative flavor to it, which is to say that the lack of representation of Ben's interest in this kind of whole process is also doing a particular kind of social work. It's re-inscribing forms of social injustice and social oppression on the basis of group membership. So I think there are sort of two conclusions to draw from this kind of disconnect in the way that we think about what kind of problems are privacy problems. So one is that there are all kinds of social informational harms that occur on the basis of these shared population features that we have with one another and that are operationalized to act on people. So I guess another way of saying this is that privacy raises problems not just of autonomy for people like Adam, but also problems of social inequality and social oppression for people like Ben that are impacted by the data that Adam kind of shares. And I think in response to this, we can really start to think about what democratic forms of institutional governance have to say about these sorts of problems, which is to say that focusing on the data subject alone says nothing about the obligations that we may have socially to people like Ben that have downstream impacts, and that these sorts of problems raise problems, sort of quintessential collective governance problems, such as how the benefits and risks of data protection are to be distributed fairly among the people with interests at stake in them, and how to recognize the mutual obligation of those in these sorts of relationships have to one another. Those are really classic and basic questions of democratic governance. I think that there's a lot of room for privacy and privacy scholarship to be engaging more deeply with how we develop and sort of implement forms of democratic institutional governance around the data flows that raise a lot of privacy concerns. Thank you.
Excellent, thank you. Another big round of applause that I want to bring. I really wish I could had like that Zoom had a sound effect that you could play that would amplify. Okay, so that was great. Thank you so much. And Ari, now we'll turn it over to you.
Great, thank you. It's always difficult to follow up such really wonderful presentations by two amazing scholars. So I'll do my best to talk very briefly about the anti-democratic effects of surveillance. And traditionally, we think about that in terms of chilling effects, right? So classic privacy scholars have written for many years about how even the perception of surveillance, like you put a camera on the corner of a building, even if it's plastic and not connected to anything, the mere recognition or the mere perception that you're being surveilled causes you to change or alter your behavior, to take privacy enhancing steps. There are great sociological studies on this about putting cameras around corners of plazas in front of buildings in New York City, where people used to, I mean, not so much today, but people used to sit and have lunch or read the paper. And then when they see a camera, they turn or they close the paper, right? So when you think about this in terms of elections and the messages that the Republican Party has sent about sending poll watchers to polling sites to make sure that nothing nefarious is going on, of course, that's bananas, that's intimidation, but it's also a form of surveillance that is meant to discourage people from going to vote in the first place. Now, that's the traditional narrative about the anti-democratic effects of surveillance. I want to talk about a slightly different way of seeing the sharing of data or surveillance as having anti-democratic effects, and that relates to this idea of normalization. We've heard this a lot in after the 2016 election. Many people, including Hillary Clinton, including others, talked about how we're not going to let Donald Trump and others normalize himself, or that separating families, this is not normal behavior at the border, and so forth. Normalization, however, is this idea that is really hard to push back on, even if we are super committed to not normalizing or not accepting this type of really evil and villainous behavior. Normalization is this idea that repeated, iterated things that you see kind of all the time that may start out as aberrant or deviant, seem over time to become less aberrant and less deviant. They become normalized. Normalization is a conflation of frequency with moral propriety. It's about something that you see and hear often. You think that, oh, well, if it's often, it's normal, and normal has a moral valence, meaning good. Think about, just as an example, think about like television watching. People who watch more television and people who see other people watch more television normalize the idea, think that it's okay and good to watch more television, right? So they confuse frequency with propriety or normative, something that is normatively good. The problem that we have is that surveillance normalizes surveillance. When you put a camera up on a lamppost on a street or at a four-way intersection, it normalizes, or it may be there to justify, oh, we're going to track people's license plates for those who run the red light so we can give them tickets. Amazing idea, sort of. But that in and of itself may be okay. But then it becomes very easy to adapt that camera, and Woody has written about this himself with a colleague of ours named Evan Selinger, who's a philosophy professor, about how it's very easy to adapt the technology that already exists with little bits of little changes. So a camera that was just going to collect license plate numbers now all of a sudden has been integrated with facial recognition technology or other AI that allows it to assess to identify who the people are in the car, who's passing by, assess their emotions based on their eyes and the movements of their faces in their cars, which is something that automated vehicle cars are trying to do. So as surveillance becomes more intense and it becomes relatively easy, there is a small marginal cost to add new surveillance technology to something that is there. As we become more inured to, or as more surveillance technology exists, we become more and more inured to it. It becomes more normalized in society. So this has anti-democratic effects. Not only have we become more inured or more accepting of greater intrusions into our lives, which can affect how we think about things, right? So micro-targeting has become a normalized part of our digital ecosystem, our daily social lives online, as well as our economic lives online. We come to expect these kinds of recommendations. But micro-targeting, when it comes to the things that we see, the news that we see, the ideas that we see, can shift and nudge our behavior and nudge our views and nudge the discourse in certain ways. That could be sometimes positive when new ideas have become normalized. It moves the Overton window, for example, but more often than not, the things that become, especially in the context of data collection and surveillance, the thing that becomes normalized is more surveillance, because the power exists inside and from the companies that want to surveil us more and more. Courts and law is not just staying out. Courts and law are being used to advance the cause of surveillance. And that's the second way I think we need to understand the normalization of surveillance as anti-democratic. Law is not absent in the slow drip of increasing surveillance in society. In fact, law has been an integral part, and this is partly Julie Cohen's argument in her book, Between Truth and Power. Law has been an integral part in facilitating data collection and in facilitating the growth and spread of surveillance technology in our society. As a result, when companies have been able to manipulate the law to serve their surveillance interests, more surveillance becomes more prevalent. They sell more products. Old technologies become updated with new surveillance technologies, become more and more part of our society. This again becomes normalized, and it's not just that the surveillance that becomes normalized; it's that the law is being used to facilitate the increase and the use of data used for surveillance purposes. For example, we have become used to a privacy law regime that is based entirely on self-governance. Our clicking yes or no, or clicking agree on a website, or toggling buttons, and so forth. And that is a performance that creates the category of what it means to be a user or an individual in the information age. But a self-governing privacy regime is entirely corporate friendly. It allows companies to essentially thrust the obligations on us and say, well, you consented to whatever kind of data collection that I'm engaging in right now. And therefore, it allows them to argue in court that people have consented to eroding their privacy rights, and then a court blesses it by saying, well, yeah, you consented, so there's no privacy violation in this additional use of your data for some purpose, whether it be micro-targeting or AI or whatever. So the things that are becoming normalized are not just surveillance, but a legal regime where companies who are increasing our surveillance are not being held accountable for it. And when that happens, we no longer live in a democracy. We live in an environment where corporations have the power to do pretty much anything they want to us, and we have no ability to hold them accountable. And that isn't democracy. That's not the way we normally think. Like, Rebecca's talk is really excellent, and her work is exceptional because it focuses so much on privacy, technology, and elections. We also and Salome's talk was great, turning that on its head and recognizing the other sides of the coin about the reverse connection between privacy and democracy. But we cannot ignore the political economy of private accountability in this environment, because that too is part of what it means to be in a democracy. The ability to hold companies accountable for abusing us, to harming us, or misusing our information. And without that, there is no democracy. There's just a lot of corporate dark money that then puts people on the federal bench who then bless their continued regime of unaccountability.
Thank you so much, Ari. More claps. Here,
and hi, Evan. I didn't know Evan was in the room. Evan and I have been talking a little bit about this online over email, and I do owe him an email. But Evan is a great source he's a fountain of knowledge and inquisitiveness on this topic of normalization, which I think we're both writing about in different contexts.
That's right. And a CLIC affiliate, might I add.
That's right.
And I'll be calling Evan out directly in a second. But before we get to that, I just wanted to actually ask one big question to all the panelists that may manifest in different ways. And then we can go ahead and go to Q&A to make sure that we've got room for a good amount of Q&A. I've got more questions, but I'll defer to the audience. And just to confirm, we go to 11:45, right, Tony? That's right. Hey, Jessica. Okay. So when you pull a panel together, you have hopes about how you think it'll go. And I just have to say, this is exactly what I wanted us to talk about. And I really appreciate all three of your presentations, because each of you hit on, I think, very critical issues. And you've identified some very big problems. And so my question to you is actually going to be the next step. It's going to be, what do we do about it? Because one of the things that I've been really interested in is the next necessary steps forward to ensure a sustainable and productive set of privacy frameworks. And so that may manifest differently for all three of you. So Rebecca, my question about what do we do about it for you has me wondering whether the solution is not to close the surveillance gap, because surveillance has this very particularized meaning about the ability to sort of use power against people. And maybe it's the right answer to try to figure out a way to turn the surveillance gap into some sort of empowering, like we turn it into a empowerment gap, and then we close that, right, in order to more empower people, not to increase surveillance generally, but rather to think about a way in which we can use data collection in a not in a sort of surveillance kind of way, in the way in which we often think of surveillance, but a way to meaningfully empower people that would allow us to have both privacy and empowerment at the same time. So I'd love to get your take on that. And then next, after Rebecca answers, I want to ask Salome whether you bring up this really incredible point, which is there are so many values implicated by informational rules that we call privacy and data protection rules that Rebecca brought up, Alan Weston, thinking about, we sort of narrowly think about autonomy as the goal of data protection rules and control over information. And so my question to you is whether the entire frameworks that we have now, thinking GDPR, thinking, there was talk in the earlier panel about HIPAA, are those frameworks oriented in such a way that it can respond to your concerns about the narrowness of the values that are protected? Or do we have to dramatically expand what we call privacy law? And if so, where does it end? Because one time I was talking, I wrote an article where I said that privacy law should be much more concerned about the externalities that the the industrial data complex imposes on people. And someone said, well, is content moderation a privacy issue? Are you saying that content moderation is now privacy? That doesn't make any sense. That's in the classical sense of privacy. So I'd love to hear your thoughts about how to move forward practically with a strategy for evolving the US data privacy framework, for lack of a better term. And then Ari, this is where I'm going to maybe save something for Evan to ask, if I'm anticipating his question. But one of the difficult things about normalization, which I do think is a key issue with our existing information law frameworks, is that a lot of normalization is enabled by the proceduralistic nature of our protections, right? So I think that creep often happens because we have protections that say, well, if you click I agree, then it's fine. And that then at scale allows companies to engineer a slow but steady creep forward. And so is the response to that to move away from some kind of proceduralism in practice? And if so, then what does that look like? And I ask with a very selfish reason in mind. Evan and I are trying to figure out whether there is an optimal amount. We've written about obscurity as a privacy value, and is there an optimal amount? And does normalization push us past a line where we could definitively say, we've now passed the sort of like climate change, right? Like there's a certain temperature at which if we hit it, it's game over. It's normalization sort of supposes that maybe there's a line there. So I'd love to hear your thoughts about that as well. Okay, so all of that, I'll now go back to Rebecca, and then we'll go in the order in which I asked.
Oh my goodness. All right. So one of the things that Michelle and I noted in our paper is that the solution to this surveillance gap problem is really difficult to pinpoint because the causes of the surveillance gap are intractable kind of societal problems like poverty, discrimination, economic subjugation, social control, all that stuff. So as long as those things kind of exist, it seems like it's gonna perpetuate the surveillance gap. But one of the things that we pointed out in the article that I think is really interesting is I was talking about this problem with a friend in Spain who's a privacy attorney in Spain, a professor. And in Europe, the surveillance gap doesn't exist because in Europe, well, we argue in the paper that that's because of a fundamental difference in how Europeans view privacy as a fundamental human right, and how it's intimately linked to dignity, and how sort of social services the orientation kind of extends to social services in Europe, so that nationalized healthcare, national ID cards, registration when you move to a new town in most countries in Europe, you register with the town registry office, which is updated and checked. And so in other words, there's no surveillance gap to speak of because people see a benevolent state as providing vital services. Whereas in the United States, we have this sort of individualized conception of fundamental liberty. This is going back to some of the work that's been done comparing Europe and the United States. But the idea is that we emphasize the right to be let alone, and that has translated into the surveillance gap essentially widening in the United States. So in terms of solutions to point to, I think what you are reaching for or talking about, Woody, is exactly sort of where we ended up too, which is that it's about figuring out ways for people who reside in the surveillance gap to exercise autonomy over decisions about how their information is shared and the benefits that they can receive as a result of potentially exercising that autonomy. But it's really complicated problem because people are in the surveillance gap for so many different reasons. So there's certainly not a one size fits all solution. And I just, I think I was involved in some work to try and figure out how many people in Virginia who had regained their right to vote had actually registered and voted. And so I was working with a guy from the Kennedy School, a data scientist, and we were trying to get the Department of Elections and the Rights Restoration Office in Virginia to coordinate with us. And he had designed this whole anonymized data scheme where nobody would be sharing, individualized data, and everybody, we'd be able to do this data matching project. But we couldn't get the Department of Elections and the Rights Restoration Office to agree to do this. And so ultimately we never were able to figure out how many people who got their right to vote back actually registered. And so, regardless of like the autonomy interests of the people who reside in the surveillance gap, like it's almost like the privacy structure that the government operates under to protect people's data privacy works against our ability to sort of move that ball forward. So it's I don't think I offered a single like cognizable solution to this problem, but I'm just giving you a sense of how complicated it is to address these issues. So it's sort of an unsatisfying answer, but there you go.
Well, no, I mean, I think it's a critical first step to understanding the scope of the problem, right? You don't want to rush in with a single solution and say that solves it all, particularly for something like that. Thank you so much. I appreciate it.
Mm-hmm.
My next step. All right. Yeah, so what do we do about it? I mean, I think in a large part, the intervention I'm making as a first step is like a conceptual point, which is that you can't address what you don't represent. And so insofar as we think that there are downstream uses of information collected about one group of people that are used to have fairly significant consequences about this other group of people on the basis of sort of features that they share with those people, we have to represent that in our data governance law. So where does that fit into models like the GDPR? I think that there are all kinds of really rich and robust answers for the way that, coming back to my scenario, the way that the relationship between Adam and Tattoo View, my clear view in this scenario, are negotiated. So the GDPR and other forms of really robust privacy protection, really, they're interested in protecting Adam's rights, and they do that by, giving Adam fundamental rights in that relationship. Other models look at imposing greater duties on Tattoo View, what they can do with Adam's information vis-a-vis Adam. And that's good. I think that that's like a robust and worthwhile endeavor to be engaged in. But, I just kind of am asking, but what about then? And that's kind of a conceptual representational issue. So I think kind of the first step is really recognizing, because of these kind of third parties that aren't external, but in fact fairly central to the point of the digital economy, which is that we use information about one group of people to make inferences and change the behavior of another group of people, that really presents a democracy problem, which is to say that there are mutual interests that impose obligations on one another, and we kind of have to think about how we develop institutional responses that impose the normative force of our actions on one another. And so, I think where that ends, I think that depends, likely depends on the particular institutional settings where these data flows have these kinds of third-party effects. So it might look like something like far more generously giving people who are affected by information flows some sort of right of action, such that they can enjoy class action lawsuits and things like that. It might look like giving people a labor right, recognizing under our National Labor Review Act a labor right over workplace data, such that labor unions can negotiate the algorithm. It might look something like a Hatch-Waxman Act for these vast amounts of private information that private companies collect, which is to say that they have a limited interest in that information, and after a certain period of time, that converts into a public good that other people can enjoy or utilize. And so there are all sorts of ways in which we can recognize what these interests mean. But yeah, certainly sort of representing them, I think, is a necessary first step.
I love it. That sounds great. I like all those ideas. All right, you're next.
So the big problem with our current privacy regime is, I think you're right, that it is proceduralist, but it's not just proceduralist. It is managerial and proceduralist, which means something that I wrote about in previously in an article in the Washington University Law Review that's talked about how, we tend to think about privacy law and law in general as an institution that hands down rules for people to follow. Privacy law and privacy governance is not that. Privacy law is a series of on-the-ground practices that have like privacy policies, assessments/audits, best practices, consent decrees that require comprehensive privacy programs. These are a series of practices that construct from the ground up what privacy law actually is in practice. And all of them are pretty much, the GDPR in particular, are rules of the road. You want to use our data, do these procedures. You want to do X, you want to achieve innovation, do this. And of course, what happens to those things is that when they're done inside a company with profit-making goals in a legal environment that is itself neoliberal, where institutions and regulations have been hollowed out, you say, the companies say, well, let's recast these and reorient these procedures and systems to suit our own needs. So that clearly is the problem, but procedure is not the only problem. Lawyers do love procedure, but procedure in the neoliberal managerial environment in which we live is not, it's, I want to say bullshit, but I guess I'll just use that. I mean, why not? So what do we do instead? I think we need entirely new governance mechanisms, and short of burning the whole thing down and building up the system from the ground up, we need entirely new governance mechanisms that focus on substantive protections. So it's not enough to say that you need to fill out a privacy impact assessment. It's certainly not enough to have a 20-year consent decree where every 2 years someone goes in and asks questions. Are you complying with the FTC consent decree? And the executive says, yes, here's a letter to that effect, without any independent investigation, which is what the FTC essentially does now with its quote unquote independent assessments. So better we have rules that say, better we have like preemptive enforcement, a more robust engagement from traditional government regulators that say this use is not appropriate. You cannot do X with data. If we want to ban micro-targeting in certain contexts for economic purposes, for political purposes, yes, we have to consider doing that. We have to stop, to use the normalization metaphor, to use the normalization idea again, we have to stop normalizing idea that the GDPR and the California Consumer Privacy Act are strict privacy rules. They are not. They are giveaways to industry, because all they do is essentially create this kind of performance of privacy that allows companies to create and have a significant impact on what privacy law is on the ground. We need to end that. And part of what ending that means is to eliminate things like choice and consents as safe harbors or as ways for allowing companies to use data, and say, you simply cannot do X with data. You simply cannot use data in an algorithm that may have disparate racial effects. You simply cannot use data in ways that endanger equality norms for the LGBT community or whatever. We used to do this, right? We used to impose, we used to have strict substantive rules that then became eroded by conservative judges who created proceduralist and managerialist safe harbors. And this was true in the common law, this was true in statutory law, and a lot of other areas. If we really care about this stuff, we need to have entirely new versions of this. Can that draw a line between what kind of surveillance up until this point? Is there a point beyond which we're going to, is this a tipping point beyond which there's no hope? Well, several scholars have tried something like that. Daniel Citron and David Gray in the Fourth Amendment context have argued that any technological use that has the potential to erode autonomy and create overarching surveillance shouldn't be used, because that starts at the beginning of the slippery slope. My response to that is just draw a damn line, right? Law used to draw lines all the time, and we just don't anymore because Republicans stopped wanting to draw lines about 30, 40 years ago, and Democrats fell in line. It's time to start being bold again and saying, yeah, screw you. We're going to draw this line, and the reason is democracy, right? The reason is because we say so. And then companies are just going to have to say, fine, we're going to follow that rule, unless, of course, the conservative stacked federal judiciary says, no, Congress can't do anything. So these rules are deeply entwined with the ability of democracy to actually function, right? Otherwise, no rules are going to work. It's going to be whatever the autocrat or the statist system wants.
Thank you so much, Ari. So for the next CLIC mixer, I'm going to have T-shirts made that for all of us to say, just draw a damn line. I agree emphatically, as you know. So that actually leads us to, now we're going to open it up for Q&A broadly. If you have a question, please raise your hands. I see Brooke has already raised his hand, and I see a question in the chat. You can type RTS in the chat. You can type your question in the chat. Whatever you feel like is the best way to ask your question would be great, but I encourage everyone to do so. I saw Louisa's question first, then I'll go to you, Brooke. Louisa asked, thinking about lack of privacy surveillance and the use of our data to fulfill business needs, Do you believe that this is a consequence of neoliberalism? Do you believe that neoliberalism is connected to our democracy crisis? And I will leave that to the whole panel to answer.
I mean, oh my God, yes, right? I mean, that is part of what I tried to get across there. I think that's 100% right. The idea, the neoliberal idea that the public good is best achieved through individual freedom is not just, we don't just live in a bastardized version of it, we live in the apotheosis of it, right? So people who say that we've bastardized neoliberalism is wrong. This is exactly what neoliberals want. The idea that public, like think about just one example. Neoliberal regulation is the idea that regulation, and so Julie Cohen wrote about this in her book, Between Truth and Power, which I encourage people to get. Neoliberalism in the regulatory state is the idea that regulators are kind of partners with and see their role as facilitating innovation in the technology space. Some proponents of this call this new governance, which is bringing in companies to have say in what happens. But that is a neoliberal ideal because it switches regulatory's orientation from command and control to being partners with what industry wants. That's part of how we got here. This focus on individual benefit as to leading to social benefit is also what justifies a self-governing privacy regime, 100%, right? So if we stop thinking about privacy on neoliberal lines and stop thinking about privacy governance along neoliberal lines, we're going to stop overemphasizing that we are self-governing agents, which of course, as psychologists have shown for decades, we are not.
I was just going to follow up on that. I mean, I think that's absolutely right. I mean, and Ari has done a good amount of work on this and has spoken a good amount on it. But, I think that the neoliberal response of hollowing out all of the welfare and regulatory, or nearly all of the welfare and regulatory capacities of the state, leaving us kind of with like a broken shell of the state. I mean, I think that the democratizing response that I'm trying to revive isn't just recapturing the idea that recapturing that the state can do things for us, that regulation can achieve substantive values for us, but the very idea that the state and regulation can do things for us, that we don't have to automatically think that anything that is done in a public function is a broken and crappier version of what we could do in the private sector, but in fact that there are huge and I would say far larger swaths of human life where we can sort of rescue the idea of self-governance. And democracy is that idea of self-governance. So if you think of neoliberalism as the idea that large swaths of our lives need to be privately ordered, democracy is the idea that large swaths of our lives ought to be publicly ordered and engage in that kind of way of governing in recognition of the mutual obligations that we have to one another. So I would say that once again, I think part of the project here and the challenge for legal thinkers in our time is to rescue the very idea that we can govern ourselves, that we don't have to cede huge portions of our lives to corporate power and corporate interests, but that we can and have in fact historically been successful at managing these things for one another.
Well, and I'll just add, I echo those sentiments entirely, and we'll just add that if you think about it, campaign finance deregulation is, probably the most direct sort of manifestation of your question, right? Which is the total deregulation of who can give money and spend money in our political system and the rules that enable that to be done without accountability. Sort of the dark money problem, and it just seems like that is sort of a natural consequence and a direct effect on our ability to govern ourselves.
Thank you all so much. I love those responses. Brooke?
So I don't quite know how this question fits in, but it's grown out of watching my wife do some voter registration work. Okay, and what I'm thinking about is, the presentations have largely focused on abuses by state and commercial interests, right? An overly surveilling punitive state and, commercialism run awry. And then significantly what happens to the individual. But, you know, in the civil society space, we also want access to information about people so we can make common cause, so we can engage in democracy enhancing social movements. So we can find out who's been deregistered, you know, tell them where they go to register, or tell them what their voting, you know, literally where their voting booth is in their neighborhood. And I think also, you know, in some of the social movements I've been involved with, you know, we do harvest, you know, names from listservs to try to get people to come out to demonstrations. And, you know, we have our own, you know, kind of democracy enhancing uses of what of a more positive form of kind of having access to information about people and their interests. And I just wonder if there's a need to focus a little bit on some of the other positive aspects of being able to find out people with common cause.
Yeah. Do y'all mind if I jump in first? I think, and I'm sure Ari will be able to speak to this as well, but I think that part of what is gained by implementing a substantive form of thinking about privacy, and I would say, you know, that's part of what I'm trying to evoke with democracy, which is not just procedural, but also has certain normative and substantive features to it, is that it allows you to distinguish between normatively distinct purposes of data production. So once you are no longer saying, am I following these sets of rules about how data has been collected and processed, but instead asking questions about for what purposes is data being collected and processed, which is a substantive question, now we can distinguish, oh, I really want to get out the vote, and I really want to make sure that these people are represented in our electoral process, as opposed to, oh, I really want to make money by like developing a fine-grained profiling like feature that tracks every single time Salome has ever thought about buying a shoe so that I can make money. Like, these are normatively distinct purposes to engage in data collection. And once we have a substantive way of evaluating those two things, we can sort of draw distinctions between them.
Yeah, I think that's 100% right. The only people that have problems drawing those lines are the kind of Rawlsian or neo-Kantian liberals who think there can be no lines, right? That there is. So I think Salome is 100% right that we have to get used to drawing substantive lines. And you know, some of my work only talks about one of them, right? There are contexts in which sharing should happen because those contexts are trustworthy. And there are other contexts where sharing doesn't achieve the same value to democracy and to society because there is no trust in that relationship. That's only one substantive value. Salome's work thinks about this differently, but on the same grounds that we have to start thinking substantively rather than just procedurally.
Well, and I guess I'll just add, shifting gears slightly.
Oh,
your question kind of animates a lot of the thinking that I've been doing, which is, you know, why is it that it's so hard to find people to help them register to vote? Why do we have this sort of information breakdown in the election space, which isn't just finding people to register them to vote, but also, you know, imperfect voter registration databases and kind of all kinds of information breakdowns in our system of democracy and in administering elections. And, you know, does that lead to potentially, you know, a system where there's, you know, compulsory voter registration or compulsory voting even, right? And we don't have to have the regime that we do where information is so broken down. But again, that would require a total reorientation of values in this country. And for the same reason we don't have a national ID card, it doesn't seem like that's going to be any happening anytime soon. But it does, I think, your question is exactly like the nub of what I'm trying to explore, which is, you know, what are the harms of breakdowns in what we think of as a surveillance society, and what does that mean for the operation of our democracy?
Thank you all. We've got a couple of good questions in the chat now. Evan asks, if normalization has become self-determinism that begets more surveillance via interconnected changes, norms, attitudes, and legal mechanisms fueling it, as a response, should we develop substantive principles or values that justify stigmatizing certain technologies and uses of data as being fundamentally incompatible with values like collective autonomy? Classic Evan question.
So this is a really good question. So this is what happens in the political sphere. You have groups. So think about it in a Foucaultian way. You have groups, powerful interest groups that have an interest in certain discourses, and certain discourses remaining narrow or remaining stable. Those discourses and the policy proposals that flow from them are what are that Overton window idea, right? Let's just think of it that way. So when new ideas come around, the Green New Deal or universal automatic registration, ex-felon voting, right? When gays marrying, when new ideas hop in, the people in power use their discursive power to stigmatize or to irrationalize those ideas. It makes no sense for gays to marry because for whatever bananas reason they offer, right? So what the tools that are used to shrink the Overton window can also be used to increase or normalize other ideas, right? So that's one possibility. So using our discursive power to act, and it has to be active and repeated and iterated, using our discursive power to stigmatize certain uses for whatever reason, whether it is based on, I mean, you choose autonomy, we could choose other totally other substantive bases, but I also think we can't just rely on the ebb and flow of powerful discourses to rationalize or stigmatize certain ideas. I think we can actively try to use law to push that stigmatization. This is the expressive value of law. We also need to go beyond just using law to stigmatize certain ideas and just say, you know, I'm tired of this conversation, and or the country is, or legislatures, people in power are just tired of this conversation, and say, we're just gonna ban something, right? We have to be willing, of course, it's not so easy, right? Like banning things could be really bad, but we have to be willing to entertain those conversations as opposed to just stigmatizing certain ideas and rationalizing others. And we also have to be careful about on what basis we do that. You know, morality is the basis on which the right has stigmatized certain ideas for a really, really long time. And we have another justice coming to the Supreme Court, unfortunately, who's going to use the same rationales, who's going to fill the empty vessel of originalism with the same morality to inform her decisions. So while we need to be cautious with respect to using substantive values that way, we also need to be much more aggressive about stigmatizing bad things, lest we let conservatives fill the void.
All right. Does anyone else? We've got one last question. We've got time for one last question before our keynotes featuring Ann Nelson's going to start at 12. So the link is in the link is in the box. So this question is from Felicity Slater, one of my star students in my information privacy law course that I'm teaching this semester, visiting at Boston University. So Felicity asks, I love the idea of baseline rules and drawing the damn line. I was wondering whether Professor Waldman, and I'll actually throw this out to the rest of the panel as a whole, has thought about a potential framework for generating such baseline rules. It almost seems like it would be helpful to have something like a Charter of Human Rights to use as a basis. Great question. What do you think? Is that the right?
I'm going to leave it to the others, to the smarter people on the panel, because
Well, hardly, but you know, I do think it seems like the European model, the fundamental rights model, you know, is a place to proceed from that, that gets you further in recognizing some of the values that we've been talking about today. But I think if you talk to people in Europe, especially critics of like Gdpr and other, you know, regulation in that space, they would take you to task for thinking that that was the solution. So I think a reorientation of why we care about privacy and what exactly the laws that emanate from that concern should look like is a place to start. But unfortunately, like it's overwhelmingly complicated. And it really, a lot of it depends on what kinds of policy goals you're aiming for. So it's really, I'm flummoxed by that question, because I sometimes get so overwhelmed by what we're trying to accomplish.
Yeah, I guess I'll follow up on that a little bit. I think that the human rights framework does certain things really well. It can protect people from forms of abuses, and it can, again, like in my little scenario, it can like prevent Adam from being, sort of having his human rights violated because of how his information is being used against him. Where it gets really complicated, and where I don't know how you can just readily apply an individual rights framework, such as a human rights framework, onto this stuff, is all of those population level relationships. I really think that those require kind of collective institutional responses. So human rights framework might be good for, giving us some substantive rules, but I think reducing our response into the form of an individual right gives people, certain individual claims, and maybe even gives them a right of exit from like abusive forms of information flows, but it doesn't give them the rights of representation that I'm interested in kind of achieving. So good, but not enough.
I think Salome is right, just very briefly, but the human rights approach can be helpful, but Europe has a human rights approach, and they, as a result of that, they created the GDPR, which half of which is empowering companies to essentially create the law on themselves through compliance mechanisms. So it's a human rights approach, but but then they created the exact managerial neoliberal governance mechanism. So you can't just have this one ideal, and especially one that is individual based if we're talking about individual human rights. I guess I don't care as much about some coherent or some single doctrine that justifies policy interdictions. People in power, if the last 3.5 years have taught us anything, people in power do what they want. So I want to gain power, and I want to achieve substantive results. And the problem, though, is, of course, that the people in power have tried to entrench themselves and tried to entrench minority rule. And these are other problems with democracy, right? So the answer is not coming up with one single doctrine that answers all these problems. The answer is fixing the system so that we can make real substantive change that may follow some elements of the human rights approach, may follow some elements of another approach.
Excellent. Way to end it on privacy, democracy, and bring it all back together again at the end. Thank you all for such an excellent panel. I've learned a ton and enjoyed it an incredible amount, so I give claps to everybody. In the spirit of sort of mimicking what a real life conference is like, I'm going to stick around for until our keynote. If anyone wants to talk to the panelists, if you would be willing to stick around for a few minutes. I thanks all, and I'll see you all at noon in the other Zoom channel.